Hello, welcome to our webinar, Tricky Sickness Issues. I'm sitting here together with my colleague Priscilla de Leede and my name is Eileen Pluijm. We're both employment lawyers at Russell Advocaten, and today we will discuss some employment law regarding the sick employee. There are lots of strict rules with regard to the sick employee, so that might raise all kinds of questions. What is expected of me as an employer? What is expected of my employee? And of course, during the outbreak of COVID-19, that also gives a new dimension to this aspect. So today we will discuss this legal framework, some do's and don'ts. On the program today, first off, the company doctor and its role within the process of the sick employee, and then we will look into the obligations of first the employer and then the employee. Then we'll look into dismissal of the sick employee. We'll highlight some of the topics that arise during the COVID pandemic. And then we will look into the role of the Works Council. And we, of course, invite you to ask your questions in the chat. And we'll try to answer these questions during the webinar. And if not, we'll get back to you later on. And also, please feel free to just contact us afterwards if you have any questions. So first off, the company doctor. It is important to know that as an employee, you are obliged to involve a company doctor. So you will have to conclude a basis contract at least with a company doctor. So this means that you will have to make work arrangements with this company doctor within this basis contract. How does the advice from the company doctor to you on prevention work, etc. So this company doctor will assist you during the process of the sick employee. So after reporting sick, he will diagnose the sickness. So it's up to the company doctor alone to assess whether the employee is really sick and if there are any limitations for his or her work. And then the company doctor will also advise you and supervise your reintegration. So you will have evaluations with the employee. It will give you advice on possibilities of reintegration. So for instance, the company doctor will tell you that the employer cannot lift any heavy bags, or that the employee cannot or can come back to work for instance 4 hours per week first and then later on 8 hours, etc. So that's all based on the advice of the company doctor. Of course, important to keep in mind the privacy involved, because there's lots of medical data. The information that the company doctor can give to you is limited because he is bound to confidentiality as a doctor. So no medical information will be provided to you, only information on the limitations or and the expected end date of the illness, but no medical data. And you as an employer can also not ask this information or record this information from your employee. So you cannot ask what kind of sickness is he suffering from. You cannot ask what are the limitations for your work. There are only a very limited set of questions you may ask. For instance, on what phone number can I reach you? Or is this caused by something that happened at work? But not what is the nature of your illness. So very important to just not ask anything or record anything. Frequent sickness, that's a very difficult situation in which your employee reports ill several times a year. For instance, 3 or 4 times for just a very short period, so a couple of days, and then he reports better again. So how do you deal with that? We would advise you to put this in your employee handbook. So write down, for instance, that after 3 times of short illness during the year, you will have a conversation, and that the employee will go to the company doctor. And in this context, it's also important to realize that a sickness and then a recovery and then a sickness again within 4 weeks is all counted as one sickness period. So that's all added together. And then it may, of course, be that you doubt if your employee is really sick. So, for instance, you see something on social media that makes you question a nice photo of this employee having dinner outdoors, or something that occurs often during the COVID time as well, is that you feel like, is my employer really ill, or is it just fear of COVID-19? And it's very important to realize in these situations, it is not up to you to decide whether the employee is sick. So you are not the doctor. That is really something that you need to involve the company doctor for. So when in doubt, go to the company doctor as soon as possible and let the company doctor reach out to the employer rather than making a decision yourself. On the other hand, it's very important to realize that you, in the end, are responsible for the reintegration of your employee. So do keep checks on what the company doctor tells you. Be critical of that as well. And when in doubt, or when you disagree with your employee on whether he is or isn't really ill, or whether the reintegration efforts made by you are enough, you can go to the UWV and ask for an expert opinion, and they will provide their opinion on that. And another option for the employee only is a second opinion. So in that case, the employee can go to another company doctor and get information on that as well, whether the advice from the company doctor is correct. So once again, when in doubt, always go to the company doctor first. Make no assessment yourself.
Well, you as an employer, you have several obligations regarding a sick employee, starting with the continuation of salary payment. And you are obliged to pay the salary at least the first 2 years of illness. And the salary is at least 70% of the recent salary. But in any case, the first year, the statutory minimum wage, so that would mean that it is possible that you have to pay more than 70% of the recent salary. It is thereby possible to make a salary supplement, for example, in the collective labor agreement, employment contract, or the personal handbook. So that means that you would say, well, the employee is entitled to the first year 100% of his salary, and the second year 70% of his salary. You can choose yourself what kind of percentage you would grant the employee if you at least pay 70%. And thereby you can apply waiting days. In principle, these days are a maximum of 2 days that you do not have to pay the employee if he reports sick, that you don't need to pay him salary. And it's actually to avoid that the employee thinks, well, I have a bad day, I'm not wanting to go to the office today, I will report sick, because of course, if the employee does not receive salary for the first 2 days, it might prevent him from reporting sick. I would like to point out the duty to inform. In recent case law, that's dealt with a lot, because you as an employer are obliged to act as a good employer, and your employee is obliged to act as a good employee. But sometimes the employee requests you something to, for example, to change an employment condition that has negative consequences for him, actually financial negative consequences. So in that case, it might be possible for you as employer that you need to inform the employee about the consequences. For example, you need to provide additional information, or you need to check if the employee is really aware of the consequences. For example, if you know that an employee is almost reporting sick, so to say, and he requests you to adjust his working hours from 40 hours per week to 32 hours per week, for example. And that would mean that if he reports sick, that he will receive salary payment based on the reduced working hours. But in that case, you might have the obligation to inform the employee that there is a less negative consequence or less negative option that he can choose. For example, that he reports partly sick, so he will be entitled to a salary payment based on his 40 hours per week that he works. Another obligation for you as employer is the reintegration obligation. Well, if you have a successful reintegration of your employee, that would mean that the employee returns back to his own work, the agreed work in the employment contract. So the first step is to see whether the agreed work can be adapted. For example, by adjusting the working time, like I just mentioned, or it might be possible to adapt some tasks. For example, if you have an employee that needs to carry heavy bags, but his own and he has back aches and he cannot carry those bags, it might be possible that you say, well, okay, you can carry on with all the remaining tasks, but we will exempt you from performing the task of carrying the bags. You need to facilitate, to allow the employee to reintegrate in that kind of work. And the third possibility is to see whether there are any tools that you can provide the employee with. For example, if someone has knee problems, that you install a stair lift, or for example, something like that, so that the employee can just continue to perform his agreed work, but in an adapted form. If that is not possible, then you're going to look for other suitable work, and as similar as possible to the agreed work. So you have to look whether there's in your organization a position available, a suitable position for the employee, so that he can reintegrate in that position. If that's also not possible, then we go to the second track. It's a so-called second track, which means that you have to look whether there are suitable positions available at another employer. And of course, there is some kind of outplacement company that will be involved to assess whether there is actually suitable work available. The question thereby is what can be expected from you, because it can of course be a financial organizational burden that you need to provide a suitable position to your employee. And in general, we can say that the larger you are as an employer and the more resources you have, the more can be expected from you. For example, if you have 5 employees and one has knee problems, well, it might not be very reasonable that you, as a small employer, provide the employee with a stair lift, for example. But it might be different if you are a bigger employer. So it will depend on the concrete circumstances of the case. If we talk about the long-term illness, it might be possible that suitable work becomes the agreed work, and it might be agreed in writing, so the employment contract really changes. But sometimes it's also that during the employment, the employee can expect that the work can be seen as his new job. So that would mean that he is not sick anymore for his previous agreed work, but he is going to perform a new position, and mostly this against a lower salary. So in case he would report sick again in his new position, he will also receive 70% of his new lower salary. We have some important moments in the reintegration process, because I saw a question regarding whether when you need to involve the UWV, when you need to report the employee sick at the UWV. So I will go through these moments and deal with the most important ones. So the first day when an employee calls in sick, like Eileen said, you inform the company doctor. And the 6th week, the company doctor will provide both parties with a problem analysis that will include all the possibilities for the employee. What can he do? What can he not do? How many hours, etc. And based on that, in week 8, the employer and employee will draft a plan of action. So that will mean that you will lay down the goals of the reintegration, and you make very concrete plans how to execute the reintegration process. And then in week 42, you have to report the sickness to the UWV. So that's not on the first day of illness, but only then. There are several evaluation moments, for example, after the first year, but also after the 2nd year. So you will look back with your employee how the reintegration goes, and do you need to adjust the plan of action, does everything goes well, etc. And you need to lay down this in the reintegration report and also make the final evaluation so that the UWV can assess afterwards whether you have met your reintegration obligations. So the do's is every 6 weeks progress meeting between you and your employee, and also follow and execute the advice of the company doctor and keep your reintegration file up to date. The consequences for you if you do not meet these obligations are that the sick employee can, of course, claim salary because he's entitled in principle to salary during sickness. There's the possibility that the UWV is of the opinion that you did not enough for your obligations, so the obligation to continue salary payment will be extended with a maximum of 1 year. So that's quite long, and during that period you need to comply with your reintegration obligations, and also the prohibition of dismissal will still apply, because during the first 2 years of illness, in principle, you cannot dismiss a sick employee. We will come back to that later also. So prevent the extension of the period in which you are obliged to continue salary payment by following the advice from the company doctor, and also if you are in doubt, just ask the UWV for an expert opinion. On the other hand, the obligation of the employee, the first one, no intentional cause of sickness. That means that the employee, or if the employee deliberately caused his sickness, he will not be entitled to any salary payment. For example, it's the case with a firework making employee. An employee who works with his hands also makes in his free time fireworks, but that doesn't go very well because there is an explosion and he got injured on his hands. So he cannot work and report sick. And the employee or the employer is of the opinion that the employee deliberately caused his sickness. But the judge is very strict, because you need to have the intention to really get sick, to that you are not able to perform your work anymore as an employee. So I can imagine that employers think that, well, my employee has deliberately caused his sickness, but it's quite strict. Another obligation for the employee is to comply with inspection provisions. Eileen also discussed that. You have to be able to pick up your phone if your employer calls. You need to go to the appointment with the company doctor so that you can assess whether you need to continue the salary payment of the employee. And in addition to that, the employee needs to work on his recovery and needs to comply with his reintegration obligations. So he needs to perform the suitable work that is facilitated by you. And he needs to follow the instructions that in order for him to be able to perform that suitable work. And of course, in the 8th week, he needs to cooperate with the drawing of the plan of action. Also for the employee, there are some severe consequences if he does not meet his obligations. The first, let me start with saying that as employer, you need to inform or warn the employee beforehand that you are going to for example, use a salary suspension, a salary stop, or even a dismissal in extreme cases. If you do not do that, you lose your right to invoke that. A salary suspension means that you do not have to pay wages when, for example, the employee does not meet the inspection provision. So if he does not come to his appointment with the company doctor, and you can just then say, well, I will suspend your salary payment, but as soon as the employee complies again with his obligations, you will have to pay the salary retroactively. And that's a little bit different and actually contrary to the salary stop, because that applies if the employee does not cooperate with his recovery or does not comply with his reintegration obligation. So, for example, he refuses to perform the suitable work that you offer to him. Then you can say, well, I will force you to comply with these obligations, because otherwise I will, or you say, I'll stop your salary payment, sorry, to force you to comply with the obligations. And that means that up to the moment that the employee complies again with his obligations, he's not entitled to salary, so he loses his right during that period. And in extreme cases, you can dismiss an employee, because during illness, the prohibition to give notice does not apply if the employee does not comply with his reintegration obligations, and you warned the employee and demanded him to comply with that. And well, then the don't is, of course, that you have to or do not suspend the salary or stop the salary without sending a warning first to the employee, because otherwise it can have negative consequences afterwards.
So moving on to the dismissal of the sick employee. So Priscilla already discussed the dismissal ban, prohibition of dismissal during the first 2 years of sickness, but there are some exceptions to the rule. So for instance, during the probationary period, dismissal is still allowed. Dismissal on the spot is still optional. So for instance, if something is stolen by the employee. Also, in case of a fixed term contract, if the end date is reached and the contract automatically ends, then there is no need to prolong the employment contract in light of the sickness. The employment contract can be ended that way. Furthermore, it's possible to terminate the contract by mutual consent, so by concluding a settlement agreement. We do, however, know that in most cases the employee is not willing to agree to such a settlement agreement during his illness, because the UWV qualifies this as a disadvantage for them. After all, the employee agrees to just stop receiving the salary that should have been paid for the first 2 years of his illness by his employer. So in that case, the UWV says, well, you forfeit your sickness benefits partially or in whole. So it has a negative impact for the employee very often. So that's why usually it is not, eventually not possible to reach a settlement agreement in such cases. So in case of reorganization, the dismissal ban actually does apply. So in case of reorganization, the redundancy of, for instance, a unit or a department within your company, you will have to go to the UWV and obtain a dismissal permit. So your sick employee cannot be terminated during this reorganization. There is, however, an exclusion for when there is a full company closure. In such a case, the sick employee can be dismissed. Something very important to keep in mind as well with regards to reorganization, that it's some kind of sometimes a bit of a trick by employees to just, when they hear there's going to be some kind of reorganization within the company, to just report sick as quickly as possible to make sure that they are protected by the dismissal ban. But it's important to know that if the request for obtaining a dismissal permit is already received by the UWV and thereafter the employee reports sick, then the dismissal ban does not apply. So there's sort of a workaround for that to prevent this, this very negative kind of thing that can prevent a reorganization from happening smoothly. Dismissal on personal grounds is also possible. So for instance, if someone is not performing well, that non-performance might not be related to his sickness, but non-performance, working disputes, there might be a ground for dismissal on personal grounds, and in that case you have to go to the court to get approval for the termination. And then after 2 years of sickness, the dismissal ban in principle does no longer apply. And in that case, you can also go to the UWV and ask for permission to terminate the employment contract. Something that's seen as quite burdensome by the employers is that first you have 2 full years in case of long-term illness by the employee, two full years of salary payment, reintegration obligations, etc. So that's quite a lot. And then when the employment contract is terminated, you also have to pay a transition compensation based on Dutch law. But that is in fact the case that even for a sick employee, you also have to pay a severance payment transition compensation based on Dutch law. However, there has been a compensation introduced, so you can go to the UWV and request a compensation for the transition compensation paid to the employer after ending his employment contract after 2 years. Something that's been a lot in the case law over the past few years is dormant employment. So in that case, the employer decides to not terminate the employment contract after 2 years of illness in order to prevent having to pay the transition payments. On the other hand, of course, the employee, he wishes to receive that transition compensation. And it has now been ruled in case law during the past year that these dormant employment should be terminated by the employee if this is requested by the employer. This is all employees, so this is all based on good employership. And as employer, you have to work along and make this work for the employee and actually pay transition compensation. So that's a recent development. Then something to keep in mind as well, if you do not comply with your reintegration obligations, then it might even come to the point that you have to pay an additional fair compensation on top of this transition compensation to the employee. So the court may rule that you will have to pay an extra compensation to the employee in that case. So that's also a negative consequence if things do not go according to the rules. So all in all, very strict. And then we'll just shortly look at some issues that have arisen during the time of COVID-19. The main thing here is that you as an employer have to provide a safe and healthy working environment. Of course, if the employee is infected by COVID-19, he's just ill. So during that time, you have to do the reintegration obligations and everything we've just discussed. But on the other hand, there are of course also quite a lot of situations in which the employee is not sick itself, but is, for instance, in home quarantine because of meeting someone that was in fact infected. In these cases, often you do have to continue payment of wages to the employer because this is seen as something that's within your within your risk. Something that arises quite a lot as well is taking temperature, wearing face masks, getting vaccinated. with regard for instance, taking temperature. Just keep in mind, due to privacy regulation, it is just very difficult and often not allowed. You should really leave that up to the company doctor, and he can only do so under very strict rules.
Yeah, and I see that we have a question. How much and for how long does an employer have to pay the compensation for transition? Shall I do that or? Yeah, because the amount of transition compensation is based on the length of the employment and is 1/3 of the monthly salary per year of service. So you will have to take into account the start date of the employment, and with taking into account the applicable notice period, you can see what the end date of the employment contract will be. And so you can calculate the transition compensation. It's not a question about how long you have to pay it. It's just a one-time payment, so to say, at the end of the employment contract. And normally there is a final settlement within 1 month of the end date of the employment contract. So that will be the moment that you pay the transition compensation to the employee. But I have to mention that it is actually up to the employee to ask for the transition compensation, and there is a limited period of time applicable to that. Then very short, the Works Council. Illness does not affect the employee's participation rights, so that means that the sick employee can simply stand for election to the Works Council, and he can also vote for or in the Works Council elections. It is possible that the sick employee is also a Works Council member himself, but the sickness does not end the membership of the Works Council. But of course it is possible that during sickness the employee is not capable, is not able to, for example, partly perform his Works Council activities. So then it might be possible, if this is laid down in the Works Council regulations, to appoint a substitute Works Council member so that the impact on the workload of the other members is minimized. The Works Council needs to be established if you have if you are an employer with 50 or more employees, and the Works Council has very important rights, such as the right of consent regarding sickness policies. Also, like we just started with our webinar with the company doctor, the right of consent also sees on the choice of company doctor, the content of the contract, and also the function of the prevention officer, so someone who ensures a safe and healthy workplace. So do take into account the rights of the Works Council and also request the consent of the Works Council in a timely manner. Well, this was in a nutshell most things about the sick employees. There are many strict rules regarding sick employees and a lot of obligations for both the employer and the employee. And in case you do not meet the obligations, there are far-reaching consequences for the employer. For example, that the continuation of salary payment will be extended by the UWV, and on the other hand, for the employee, he might lose his right to wages. So do set clear rules, written rules, for example, in the employment contract or in the personal handbook, how the employee needs to report sick, what kind of percentage of wage he will receive during sickness, etc. And also follow the doctor's advice, and so involve the company doctor and follow his advice, and keep up the reintegration file, because it's very important that you can show the UWV whether you complied with all your reintegration obligations, and thereby communicate clearly with the sick employee, and not only during the sickness, of course, but also upfront, because preventing is of course better than cure. And when you are in doubt, you can always ask your company doctor or ask the an expert opinion from the UWV if you're doubting to sickness, or you have any questions regarding reintegration, and always ask legal advice if you would like to impose a salary suspension or a salary stop or even a dismissal. I see a question. The Works Council is indeed the ondernemingsraad. That's right. Yeah. So actually, this was is the end of our webinar. Thank you for participating in this webinar. And if you have any questions that were not answered during this webinar, you can always leave a message in the chat, or you can send us an email.